we had. It never happened before that a Zoom meeting just disappeared on my account, and I am very, very sorry for the inconvenience we caused and also for the delay of 15 minutes. But I say hello now to everyone who's arriving, and I'm very much looking forward for those who will join in a couple of minutes. So good morning to the participants from Chile, and good afternoon to the listeners in Germany and Tanzania. I am very much looking forward to this event, this new event, and I say a warm welcome to the first Chilean-German-Tanzanian legal talk. So my name is Caroline Herzog. I am the project manager of the Tanzanian-German Center for Eastern African Legal Studies, which is a cooperation project between the Universities of Bayreuth in Germany and the University in Dar es Salaam, Tanzania. Together with Dr. Sven Corzilius from the Heidelberg Center Latin America, we have launched this new event to bring together scholars from the Global South and also to broaden our horizons and to have a new comparative perspective on human rights. So I'm very much looking forward to this event, to having 3 speakers today from different time zones, from different also backgrounds, legal backgrounds. And before we start off with our 3 presentation, I would like to welcome Mrs. Ines Recio, who is the academic director of the Heidelberg Center Latin America in Germany. Please, Ines, a warm welcome.
Thank you very much, Caroline. Good afternoon also from me in Germany and in Tanzania, and good morning in Chile, and to all the participants attending the talk from the Americas. I am very, very pleased to welcome you to our first Chilean-German-Tanzanian legal talk. First of all, I would like to thank the initiators and the main organizers of the talk, Dr. Caroline Herzog, Professor Toko Kaime, and Dr. Sven Corzilius, as well as our 3 speakers. They have put together a very interesting program composed of 3 talks that will surely lead to a very lively and very fruitful discussion. Professor Jesse James, Professor Toko Kaime is project leader, researcher, and lecturer at the Tanzanian-German Center for Eastern African Legal Studies. Rita Lages is researcher and lecturer at the Human Rights Center and the Faculty of Law of the University of Chile. And our 3rd speaker, Sven Corzilius, is a lecturer and a researcher at the Heidelberg Center Latin America in Santiago de Chile and at the Faculty of Law of the University of Chile. If there is a good way to show that cooperation should have no borders, then it is this event we are holding today. It reunites centers of excellency in research that literally cover most of the globe and whose output in research and other activities has an impact on at least 3 continents. The Tanzanian-German Center for Eastern African Legal Studies in Dar es Salaam in cooperation with the University of Bayreuth in Germany, the Center for Human Rights at the University of Chile, and the Heidelberg Center Latin America in Santiago de Chile, which is Heidelberg University Center of Excellence in Teaching and Research in Latin America. The institutions I just mentioned are already connected pairwise through highly specialized LLM programs and through joint international projects. Many of these projects are funded by very prestigious foundations, by the German Academic Exchange Service, or by core governmental institutions. And this support acknowledges the innovative, collaborative research on issues that are crucial for the advancement of societies at present. And it also acknowledges the excellency of the researchers and the lecturers. And it is on this basis that the Tanzania-Germany cooperation of the TGCL and the Chile-Germany cooperation at the HCLA offer their master's programs aimed at training the future leaders in East Africa and in Latin America. Alumni of these two masters of law later become new generations of young researchers and of young professionals in national and in international policy-making institutions. Some of the graduate students also end up being lecturers of the master's programs themselves. And these people are graduates together with the lecturers and researchers. They come from a number of countries in Latin America and in Africa, so they are the greatest ambassadors for promoting a way of thinking and a way of acting that considers regional and international cooperation, interdisciplinarity, and knowledge transfer as an important motor to define societies in the future. Today's talks concern human and fundamental rights, and no one can deny that we are dealing here with highly topical issues, not only because they affect societies as a whole and worldwide, education, people, health issues, trade, economy, but also because so much change is going on those issues nowadays that might be definitory for the panorama during the next decades. A paradigmatic example will be dealt with, for instance, by Sven Cotzilius with regard to Chile. Where are the intersections and how are the interactions between constitution-making processes and debates on fundamental rights? Professor Jesse James will offer detailed insight into the current legal framework in Tanzania concerning human rights, and Rita Lage will discuss contemporary issues and challenges on migration and on asylum law. In Europe, you might know that we are currently attending a lively debate on a common asylum policy for European Union member states, and considerations of legal frameworks in each country and knowing how human rights are dealt with in the countries of origin of the migrants are very important to advance together on these issues in a sustainable and in a respectful manner for all the parties involved. I would not like to finish these welcome words without mentioning also the potential of our event beyond today's scientific debate. Today's talk are meant to be a way of exploring possibilities to expand academic cooperation in research and in teaching beyond our respective regional focus. So we take this first Chilean-German-Tanzanian legal talk as an optimal starting point to intensify multilateral exchange and to enhance the interest of young and senior researchers concerning the chances that getting to know each other offers for scientific advancement, which is also key for the advancement of societies. So again, I thank very much all institutions involved in the event, the organizers, the speakers, our moderator, Caroline, and last but not least, all participants attending the talk from different parts of the world. I wish you a very interesting and inspiring talk. Thank you.
Thank you very much, Mrs. Ines Recio. Very nice words, and yeah, thank you for highlighting the importance of academic cooperation. Now I would like to hand over the project leader of the Tanzanian-German Center for Eastern African Legal Studies to also welcome our participants.
Okay, good morning, good afternoon, good evening, depending on where you are. I'll be very brief in my remarks since we are already running quite late. I would like to thank our organizers of this event. I think the fact that we are all here shows the potential that universal human rights norms have, and to meet across space and time in this way affirms my belief that human rights everywhere matter to everyone in every place. Particularly grateful to our presenters this afternoon, Dr. Jesse, Professor Rita, and Dr. Sven. Thank you so much for making this time. And lastly, I'd like to thank all our participants for your patience. I'm really sorry about the technical difficulties that we had earlier, and I'm grateful that you were able to wait whilst we fashioned a solution for that. And with that, I welcome you all. I'm looking forward to the talk this afternoon. Thank you.
Thank you very much, Professor Toko Kaime. So before we start with our presentations, I would also like to kindly ask every participant to unmute, to mute themselves, and maybe also to turn off the camera for those who are not speaking, to avoid any further technical difficulties and to avoid interferences. And I think that is easier, especially as participants are all over the world, so that we can a little bit reduce the data. All right, so I would like to hand over then to Dr. Jesse James, who is our first presenter, and he is lecturer at the Department of Economic Law. He is an experienced educator and practitioner in human rights law, land law, and constitutional law, and also in media law. And today he's talking about the Tanzanian Constitution and the relationship with human rights. Please, Dr. Jesse James, the floor is yours.
Caroline, thank you very much for inviting me to speak at this occasion, and also I appreciate and thankful to all the organizers of this event, and I also acknowledge the presence of the participants who are following our discussion today. And good afternoon, good evening, good morning, wherever you are. This discussion, when I was invited to speak, and then I thought that I should share with you a little bit of understanding of the Tanzania human rights system. And my discussion will be around the three main components. I'll speak a little bit about the introduction of Tanzania pertaining to the history of human rights according to the development of the Constitution of Tanzania. And then I'll speak a little bit about the Bills of Rights of the Constitution of Tanzania. And then finally, I'll talk about the redress for violation of human rights in Tanzania. Maybe I should start by saying that when I speak of Tanzania as a country, before 1964, there was no country which was called Tanzania. There were two sovereign countries which were Tanganyika and then Zanzibar, until their union on April 26, 1964. But before that, we had separate countries, and Tanganyika, which is a bigger country comparing to Zanzibar, we have a population of almost about 54 plus the population right now. Zanzibar has about around 1 million population, and therefore Tanganyika has been a very big country comparing to the two to Zanzibar. So Tanganyika was colonized by the German in 1980s until 1919, and then thereafter the British took over, and then under the League of Nations trusteeship and UN trusteeship, then Tanganyika was under the British from 1919 to 1961, when Tanganyika was given independence. And Zanzibar was also under the British, but also was given independence in 1962. Tanganyika formerly was the part of the German East African before it was given over to the British, and the British colonized the. Sometimes we say that we are colonized by the British, actually, but strictly speaking, we were not colonized, but it was under the UN trust. It was UN trusteeship territory. We got independence in 9 December 1961, and the first constitution of Tanzania, independent constitution, was the Independence Constitution of 1961, which actually did not contain a Bill of Rights. The Independence Constitution was passed by the British at Westminster. It had no Bills of Rights because during the negotiation for independence, the nationalist leaders did not want the Bills of Rights to be included because during that time, after independence, the Queen of England was still the head of the state and the government of Tanganyika, and was also the commander-in-chief of the armed forces. So Tanganyika was not really Republican from in 1961 when we got independence, but it became Republic state in 1962. So the nationalist leaders were fearing that because foreigners, British nationals were still in Tanganyika during that time, so they thought that the inclusion of the Bills of Rights in the Constitution probably will hamper the new government into doing what they are supposed to do. For instance, they were saying that they want faster development, and therefore probably they thought about expropriating investment by the foreigners, and therefore if we will have the Bills of Rights in the Constitution, then that will hamper, that will prohibit the government from taking the action it wanted to take. So in 1962, as I've said, it became Republican, but still, and that's the time when the African president replaced the Queen as the head of the government and the state and the commander-in-chief of the armed forces. And we had the Republican Constitution of 1962. But the Republican Constitution also had no Bills of Rights, just like the Independence Constitution. And Mwalimu Nyerere, the first president of Tanganyika, who is also the father of the nation, proposed the creation of the Permanent Commission of Inquiry to safeguard national ethics, but also restraining the abuse of power by the executive. He thought that by having a commission on inquiry, which will safeguard the national ethics and also restraining abuse of power by the government, then that will be enough instead of having the Bills of Rights. That was 62 to 1964. 64, a new constitution was adopted. This was after the following the union between Tanganyika and Zanzibar, and it was agreed during that time when Tanganyika united with Zanzibar that the Constitution of Tanganyika of 1962, the Republican Constitution, will be temporarily used as a constitution of the United Republic of Tanganyika and Zanzibar. And the president was given power to pass a law, and by using that power that he was given, then he modified the Republic Constitution to accommodate the Union. And this Constitution also had no Bills of Rights, but it did not even make recognition of fundamental rights. And later, thereafter, in 1965, an interim constitution, the third constitution, which is called an interim constitution, was passed, and it declared Tanzania to be a democratic society, but it abolished the multi-party system. So from 1965, with the interim constitution, Tanganyika became a single or one-party state, and also bills of rights was not included in the constitution. The constitution of 1965, which is called the interim constitution, was not expected to last longer, but unfortunately it lasted longer until 77, when it was replaced by the constitution that we have right now, which is called the Constitution of the United Republic of Tanzania of 1977. So the constitution that we have right now was adopted in 1977, but also this constitution did not contain the Bills of Rights. The Bills of Rights was not included until 1984. So it's until 1984 that Tanzania, which now was a union between Tanganyika and Zanzibar, included a Bill of Rights in the constitution. That was through the 5th constitutional amendment. In Kiswahili we call sheria marekebisho ya 5 katika katiba ya nchi ya mwaka 84. That's when the Bills of Rights was included. But also when it was adopted in 1984, the government wanted a grace period. So it was not applicable, it was not justiciable from 1984-85 when it came into effect until March 1988. And the government by that time, it said that it wanted to make its house in order by repealing or amending those laws which were infringing the human rights. But it's very unfortunate that until when the Bills of Rights became justiciable in 1988, the government did not do that. And subsequently, you will find that when the country wanted to move from a single party system into a multi-party system, there was a presidential commission which was appointed, which is famous known as Nyalali Commission. And among other things, it noted that there were so many laws in Tanzania which were against the Bills of Rights. Actually, it noted about 40 plus laws which were against the Bills of Rights, and they proposed to the government that they should amend those laws or repeal those laws. Of course, to date, some of them have been amended, but some have not been amended. And there have been cases here and there most of the time when human rights activists have been going to court and challenge those laws. So there were many reasons for the government to adopt the Bills of Rights in the Constitution in 1984. But one of them was, during that time, the African continent adopted the African Charter on Human and People's Rights. In 1984 and 1981, you will remember that the African Charter, the African state under the OAU, Organization of African Unity, now it is AU, adopted the African Charter on Human and People's Rights. And Tanzania participated in the formulation of that charter, and therefore, having no Bills of Rights in the Constitution, then it will raise question on our sincerity in protecting and promoting human rights in the African continent. And therefore, the government, through pressures, external pressures and internal pressures, finally decided to adopt the Bills of Rights in the Constitution. So when you look at the Constitution of Tanzania 1977, now it has been amended several times. Our Constitution contains so many patches. As I speak right now, our Constitution has been amended 15 times until 2005. And it is comprised of a section on fundamental rights and freedoms and other protection, but also, just like the African Charter, it contains duties. So it does not only contain the fundamental human rights and freedoms, but also it contains duties for all citizens of Tanzania. And this runs from Article 12 to Article 28 of the Constitution. Normally, when I teach my classes, my class, I normally refer them to Article 29 of the Constitution, which I call it that it's an article which contains essential principles governing the fundamental rights and duties of the Constitution. Among other things, in that article, it says that every person in Tanzania has the right and duties. He has the right to equal protection under the law, and no citizen shall have a status, right, or special position on the basis of lineage, tradition, or descent, and no law should confer any such right, status, or special position. And it concludes by saying every person has the duty to conduct himself or herself and their affairs, not to infringe upon the right and freedom of others or the public interest. It's like the last clause is a reflection of Article 27 of the African Charter on Human People's Rights. Among other things, it's put limitations on the rights that as you enjoy your rights, you should not infringe upon the rights and freedom of others. So when you look at those rights we have from Article 12, I'll just mention them briefly without elaborating them because of the interest of time. Most of the rights which are contained in the Bills of Rights are civilly and political rights. We have shortage of economic and social rights in our Constitution. You will see Article 12, we have the right to equality of all people. Article 13, there is equality before the law, including the right against discrimination. And then in Article 14, there is the right to life. Article 15, there is right to personal freedom. Article 16, there is right to privacy and personal security. Article 17, there is right to freedom of movement. Article 18, there is right to freedom of expression. Article 19, there is right to freedom of religion and the right to practice religion. And then Article 20, there is a personal freedom of association. And then there is and then there are duties. The duties start from Article 25. There are duties to participate in the work that Tanzania have affirmative duties to contribute toward the society, and they are supposed to work, but that does not include forced labor. Also, there is a duty to abide by the law of the country that is provided in Article 26, and then there is a duty to safeguard public property that is under Article 27. There is a duty to defend the nation. Whenever you are required to save the nation, you are supposed to do so. That is Article 29, Article 28. And then with regard to economic and social rights, there are only two rights, the right to work and the right to property. Other economic and social rights are not there, but there is a section in the Constitution which actually is not justiciable. It is part 2, it's called Fundamental Objective and Direct Principles of State Policy, which among other things, it included the right to education. But the Constitution itself says that that part which does not form part of the Bills of Rights is not justiciable. Therefore, as you can see, there is a shortage of rights in the Constitution. Last year, from last general election 2015, that was from 2016 coming from 2013 coming to 2015, we had a constitutional review process, and we thought that we will have a new constitution which will include many rights, because the commission, which is appointed by the president, proposed a number of rights broader than the ones that we have. But unfortunately, that constitution was never passed, and it is still the government, the present government has said that is not the priority of the government at that time, and therefore we are still using the 1977 constitution. Now, in case of violation, what do you do? Article 30 of the Constitution gives mandate to only the High Court to address the violation of human rights. In terms of the court structure, we have from the primary court, district court, resident magistrate court, and then the High Court. But it's only the High Court that has been given mandate to interpret the Constitution. So whenever even a person feels that his right has been violated, he has to go to the High Court. And it's quite unfortunate that even the procedure of going there is not simple. And unlike other cases, the composition of the bench is supposed to have 3 judges. So every time you want to go to court to litigate, if it's not matters concerning admissibility or jurisdiction, it's a matter concerning merit, then the 3 judges have to be there. This has been noted by human rights activists and also scholars that it inhibits access to the court in terms of vindicating human rights, but the government has not accepted to change that position. The position is still the same. And also from 1994, when a law for enforceability of human rights was enacted, that law is called the Basic Rights and Duties Enforcement Act. But read it together with the Constitution, there were 2 ways of going to the court. One was under Article 26(2), which every person could take a legal action to ensure protection of the Constitution, which means the public interest litigation could be filed under using Article 26(2). And there is Article 30, Article 3, which allows any person who is a victim of human rights to take action to the court. So there were 2 ways. Either you go through the public interest litigations, or you go as a victim. But coming from June 10 this year, the Parliament has amended that law and they narrow the criteria for legal standing to challenge the law or action that is alleged to violation a constitutional bills of rights. And that law says any individual seeking to use the remedy of vindicating human rights, he has to show that he has been personally affected by the act or the law. So you must be really a victim in order to go to challenge a law or an action violating human rights. There has been a lot of concern from human rights activists, but also scholars, that this is unfair because, and some scholars, for instance, a famous Professor Emeriti, Professor Shivji, actually has been arguing that these provisions or these amendments have brought to an end public interest litigation in Tanzania, because the provision of the Constitution, Article 26, Sub-Article 2, was being used by civil society organization or any other person to take a matter to the court despite the fact that he is a victim. For instance, if there is a law passed by Parliament which is violating any provision of the Constitution, then someone will go to the court. Maybe to also, I should say that another organ which is vested with the role of protecting human rights in Tanzania, apart from the High Court, it is the Commission for Human Rights and Good Governance. With the Commission for Human Rights and Good Governance, it is established under the Constitution, it has its law, and it has been given mandate to protect and promote human rights in the Constitution. But as you know, normally Commission do not have their decisions are not binding, they are merely recommendations from the government. And there have been occasions where the Commission has been making a recommendation to the government, but the government is not responding positively to the recommendation of the Commission. But it's a way where small disputes on violation of human rights can be addressed by the Commission instead of going through the court. Maybe also I should point out that it's not only the Constitution, but also there are some other laws which also promote and protect human rights. And basically, I can mention only 3 laws, and then I will end my presentation. And that is, we have the Law of the Child Act, which is protecting or safeguarding the rights of the child. We have Person with Disabilities Act, which is also protecting the rights of persons with disability. We have the Tanzania HIV/AIDS Control and Prevention Act of 2008, which is trying to protect the rights of persons living with HIV/AIDS. And I can also mention that we have a Refugees Act, which is also addressing matters concerning refugees in Tanzania. These are specialized law that I can mention or I can referring to that also add onto the legal framework for protection of human rights into Tanzania. But I will not go far to discuss about the situation regarding human rights in Tanzania, but in passing, I can just say that there has been a challenge here and there concerning promotion and protection of human rights in Tanzania, because in the current regime, there has been a lot of concern that there are many laws which have been passed, which actually are trying to inhibit or limiting and violating human rights of the people. And basically, the main 2 rights which have been affected mostly are the freedom of expression, freedom of assembly, probably the freedom of association, because there are laws related to that. For instance, the Media Service Act, the Cyber Crimes Act, the Electronic and Post Communication Online Content Regulations. All these have been mentioned by human rights activists, journalists, and the opposition political parties, that they've been used by the government to limit and to infringe rights of people. In my presentation, I think I will share with you, you will see some of the links which shows the situation of human rights in Tanzania as we speak right now. With those remarks, Caroline, let me end my presentation there. And if there are any discussion thereafter, then I will be able to say more. Thank you very much for listening.
Thank you very much for this insightful presentation, Jesse James. Yeah, that was very interesting to hear about the legal framework on human rights in Tanzania. And yeah, it was very exciting for me also when you mentioned the current situation, and you mentioned, for instance, that there is next to the Constitution a lot of other acts like which are protecting the rights of the child in specialized group. But on the other hand, also very interesting to see that there are crimes which are actually putting in danger the human rights, especially with the Media Act and the Cybercrime Act.